180 multi number one, proper names, Patrick Brown, Madison County Sheriff's Department, Commercial Crimes Bureau, Mr. Brown, Madison, Butte Junior College, Mr. Phillips, Associate of Applied Science, Fire Technology, National Fire Academy, Great Falls, Montana, United States Army, Huntsville, Alabama, State of North Dakota, International Association of Arson Investigators, Superior Court, State of Montana, Grand Forks Street, Madison County, People's Exhibit number 10, People's Exhibit numbers 3, 4, 5, and 6, People's Exhibit number 3, People's Exhibit number 4. I'm Mr. Phillips.
The witness,
The court.
Mr. Phillips.
the witness,
The court.
State your name for the record, please.
my name is Patrick Brown.
And what is your occupation?
I am a sergeant for the Madison County Sheriff's Department, currently assigned to the Commercial Crimes Bureau involving arson, explosion, or any other similar type of crime.
How long have you been a police officer?
I have been a police officer for over 20 years.
How long have you been assigned to the arson detail?
A little over 5 years, sir.
Mr. Brown, could you tell the jury what your job as an arson specialist entails?
Yes, sir. Upon notification of a fire in any of our areas within the County of Madison, we respond to the location to determine the cause and origin of the fire, whether or not it was accidental or criminal in nature.
What type of training have you had to qualify you in determining whether the fire was criminal or accidental in nature?
When I joined the detail approximately 5 years ago, I was assigned to work with different officers who had a combined experience and expertise in excess of 60 years. I also have had training and hold a degree out of Butte Junior College.
Just a minute, Mr. Phillips. What is that degree in?
It is an Associate of Applied Science in Fire Technology.
All right, thank you, sir. Mr. Phillips, you may continue with your questioning.
All right. Is there anything further you would like to tell us, sir?
I have successfully completed a course at the National Fire Academy in Great Falls, Montana. I have had training and attended a 150-hour course given by the United States Army at Huntsville, Alabama. A portion of this course was for arson as well as incendiary devices. I have attended seminars and training given by the state of North Dakota.
Is there anything else? Do you belong to any associations or do you hold any other certifications?
I am a member in good standing with the International Association of Arson Investigators. I've examined and testified in excess of 50 times in Superior Court in the state of Montana.
Was this as an expert?
Yes, sir, it was.
Mr. Brown, directing your attention to the early part of December of 1982, did you have occasion to go to the address of 304 Grand Forks Street in Madison County?
Yes, sir, I did.
What was the first occasion in which you first went there?
It was on February 10, approximately 10:30 or 10:45 in the morning.
Could you tell the jury what you discovered when you arrived at that location?
Yes, sir. When I arrived at the location in question, my first observation was that it was a single-family dwelling located on the north side of Grand Forks Street. The house itself was primarily of wood construction with various different types of roofing materials. In the main portion of the house, there were 2 bedrooms, a bathroom, a living room, and a kitchen area. Also attached to the rear portion of the house was a separate bathroom and bedroom. The structure itself also had a second-story bonus room or recreation room in the rear portion of the house, which is over the patio area.
Could you describe the condition of the house when you arrived?
Yes, sir. Immediately upon entering the residence, I observed that the structure had suffered extensive fire damage.
Where was the most damage? Was it in the front portion of the house or where?
The primary area where the fire damage occurred was in a northwest bedroom in a hallway area and also the living room. The structure itself had heavy fire damage in the rear roof area where the second-story bedroom was located.
Directing your attention to People's Exhibit number 10, there is an area which has been designated northwest bedroom. Is that where you determined the fire to have originated?
Yes, sir. It was in that area, correct.
I show you People's Exhibit numbers 3, 4, 5, and 6.
Would you hand me those exhibits so that I know what it is that you were talking about?
Yes, Your Honor. Now, directing your attention to People's Exhibit number 3 for identification, would you describe what that depicts?
Yes, sir. This is a picture of the northwest bedroom, which is shown in the diagram. It is a photograph which shows the west portion of the bedroom that faces the east wall. It is where a dresser had been located.
Mr. Brown, what is this dark area here?
That is a wooden frame directly in the middle portion of the photograph that appears to be sort of an orange color. That was a wooden frame that the bed itself was sitting on. Directly above that, in the top portion of the photograph, is the portion where the headboard of the bed would be.
Would you describe People's Exhibit number 4 and what that depicts?
Yes, sir. This is also a photograph taken from the same bedroom, a little closer to the south. It is aimed on the portion of a bedroom door that takes you from the bedroom into a common hallway. You can see directly in the center of the photograph an area which depicts the living room. In the upper portion of the photograph, it shows extensive fire damage with Mr. McKenna? Oh, Mr. Atelier.
All right,
What's your
this
names?
is 180 multi-voice number 2. Proper names, Mr. Mehana, Mr. Atelier, Assad Farah, and Edward. I'm going to be Ms. Dunnett.
The witness?
Miss Mackey.
Ms. Dunnett.
The witness?
Miss Mackey.
Mhm.
Okay. I think we got to the first check of May 20th, 1991. And now the date of his next check
June 5th, 1991.
and the amount of that check.
$2,500.
And how was the compensation for that check determined?
That was a specific amount determined by Mr. Mahana to cover for no commissions paid in May.
Now, the original $3,000, was that a draw against commissions?
No, it's a base pay.
The $2,500 paid on June 5th, 1991, was that a draw?
No.
Was that in addition to the base pay?
Yes.
Now, the next time that Mr. Atelier was paid,
June 19th,
and how much was he paid at that time?
$3,500.
And how was his compensation calculated for that payment?
It was a base pay for June.
If it would make it easier for you, she's referring to document number 9 that she had prepared.
Now, how was that compensation determined?
The June 19th,
Yes.
$3,500 was base for June's base pay.
And how was it determined that that was June's base pay?
At that particular time, there wasn't a pay plan in effect, so Mr. Mahana said to pay $3,500 for the base for June.
Were you present during any negotiations that might have taken place between Mr. Atelier and Mr. Mahana regarding that amount of money?
No, I was not.
So do you have any knowledge of how Mr. Mahana determined that that amount of money would be paid?
No, I don't.
Did you receive anything in writing from Mr. Mahana telling you to pay $3,500?
I'm not sure.
You weren't employed, were you?
No, I wasn't employed at that time.
That's true. Do you know whether in the file there is any document that shows that Mr. Mahana put in writing the amount that Mr. Atelier was to be paid?
I don't know.
Let me have you take a look at number 41. It looks like a message dated 6/19/91.
Okay.
Can you tell whose signature there is on that message?
That's Assad Farah.
And do you know what his position was at that time?
No, I don't.
Do you know whether he would have had the authority to authorize wages to be paid?
I don't know.
I'm going to have to ask you to clarify what I thought was your testimony. I thought that you testified that Mr. Mahana authorized that the $3,500 be paid to Mr. Atelier on the June 19th payday. Is that correct?
Yes.
How do you know that?
When I did this report, I asked.
When you did what report?
This report here, this number 9,
Who did you ask?
Mr. Mahana,
When did you prepare number 9?
when Mr. Ateye was terminated
So that would have been approximately when this document was prepared,
in August. It was within a couple of days of Edward's termination date.
August of 1992.
2.
In fact, you have no personal knowledge as to whether or not Mr. Mehana authorized that 3,500, do you?
Personal knowledge based on the way business was conducted, I would say yes. No one did anything without his knowledge or authority or okay. Regardless of who signed that, he had the final say.
The next payday for Mr. Ateye was when?
July 31st, 1991.
And how much was he paid at that time?
$9,569.50.
And how was that calculated?
It was a $3,000 base pay for July, a $3,000 base pay for August, and commissions from the June financial statement of $3,469.50, and $100 that I can't identify.
Do you have the calculations with you or the documents with you to show how the $3,469.50 was calculated?
No, we did not bring the 91 financial statement.
I'd just like to make an objection here as to relevancy of this line of questioning. It's not relevant. It's not likely to lead to the discovery of admissible evidence, since Mr. Ateye's claim, I believe, is limited from lost wages from January 92 through July 92.
Let's just skip ahead to the January 92 compensation, which would have still been calculated on the 2% of the total gross profit. Is that correct?
Yes,
Is it correct that if the change was to go into effect on February 1st, 92, then it would have affected everything after February 1st, 92? Is that correct?
yes,
So on the payday of January 2nd and January 16th of 92, both of those were still under the old plan. Is that correct?
correct.
Do you have the documents with you to show how the commission was calculated?
I'm not sure if we have the December 91 financial statement.
I would appreciate it if you would take a look.
We do not have the December.
Okay, let me see if I have it.
January pay is based on the December commission.
On December?
Right, so his January base. This is December commissions.
Would that have been true for February, on the February plan, or on the February payday of February 3rd of $3,000? And I'm
This one goes back to Mr. Phillips, right?
okay. The 160 multi-voice number 1, proper nouns, people, Amy Martin, Amy, Lexington, Mrs. Pittman, Mrs. Forbes, Bill, Mr. Brubaker, Louisville, Kentucky, Mayfield, Lexington School, Louisville, Lexington Elementary. And I'll be Mr. Phillips.
The witness,
The court.
Mr. Phillips.
the witness.
The court.
Start with the court.
Let the record reflect that the jury are present, counsel are present, defendant is present. You may proceed.
The people call Amy Martin.
You may get up here on the chair. Now, can you tell us your name, please?
Amy
Amy. And your last name?
Martin.
Can you spell your last name?
Martin.
Is your last name spelled Marten?
Yes.
Okay, Amy, can you tell us how old you are?
6. I mean, almost 7.
Okay, when will you turn 7?
November 28th.
Okay, Amy, I'm going to ask you to answer out loud so everybody in the courtroom can hear you. Okay? That's real good.
Okay,
Maybe you can help out by keeping your hand away from your mouth. Can you do that?
I guess so.
You go to school, Amy?
Yes,
Where do you go to school?
Lexington,
What grade are you in?
first.
And do you have a teacher?
Yes,
Who's your teacher?
Mrs. Pittman.
And did you have a teacher last year?
Yes,
Who was your teacher last year?
Mrs. Forbes.
Now, Amy, do you remember that you just held up your hand, your right hand, and you told that lady over there that you would tell the truth?
Yeah,
Do you know what the truth is?
yeah.
What is the truth?
I don't know how I can explain it.
Okay, do you see what I am wearing today?
Yeah,
If I told you I had on a black suit, would that be the truth?
no, it wouldn't be the truth
Why?
because it is light brown.
All right, if I told you I had a blue tie, would that be the truth?
No,
Why is that?
because it's really brown with polka dots, with white polka dots.
Okay, now, Amy, do you know what happens when you don't tell the truth?
Yeah,
What happens?
I don't know. Forgot.
Okay, well, have you ever gotten in trouble before?
Yeah,
Do you know what happens when you don't tell the truth?
yeah. I got a spanking.
Okay, are you going to tell us the truth today?
Yeah,
Amy, do you know a person in the courtroom by the name of Bill?
yes,
Okay, and you have to look. Do you see Bill?
yes.
Where is Bill?
Over there.
And is he wearing a dark blue jacket? I will stipulate that she has identified Mr. Brubaker. We will so stipulate.
Stipulation is accepted and prescribed that whenever counsel stipulate or concur on a fact or facts that is deemed to be conclusive.
Okay, Amy, how is it that you know Bill?
I don't know.
Okay, well, have you seen him before today?
I don't know.
All right, do you remember at the beginning of the school year, Amy, that is just when you started the first grade?
Yeah,
Did you live in Louisville, Kentucky?
no.
Okay, what is your address? What was your address when you started school this year?
What?
Can you tell me?
No.
All right, you have to answer out loud. A shake of the head is not going, we've got to have more than a shake of the head. You can't tell me? You don't know?
No, I can't tell you.
All right, do you know what city you lived in at the beginning of this year?
Yeah,
Was it Louisville?
Mayfield.
Okay, now you go to Lexington School, is that right?
Yes,
Do you know Lexington School, what city it's in?
Louisville.
When school started this year, did you live near that school, Lexington Elementary?
No.
All right.
Will counsel come to the bench off the record? Ladies and gentlemen, because of the floor plan, the courtroom set up, I am unable to see Amy while she is testifying, so I think it's better if everybody in the courtroom is able to see witness. That's the reason I'm going to sit in one of the chairs by the rail. That's the reason I am doing it.
Amy, I was asking you if you knew where you lived, in what city?
Mayfield.
Okay, now did you used to live with Bill?
Yes.
Okay, when did you live with Bill?
I don't know.
All right, were you living with him just before? Well, I withdraw that. Did you live with Bill during the time between kindergarten and first grade in the summer?
Yeah.
Okay, when you were in kindergarten, did you live with Bill?
Yeah.
All right, and do you live with Bill now?
No.
Now, Amy, when you lived with Bill, did some things happen between Bill and you?
Yes.
Okay, can you take your finger out of your mouth, please? Amy, do you want something to hold on to? What do you want? There is a pencil. All right, this is multi-voice 160. Number 2, there are no proper names. I'm going to be Ms. Wilson.
The witness,
Mr. Joyner,
Ms. Wilson,
the witness,
Mr. Joyner.
how much time did you watch your traffic light from the time you first noticed it until the time of the accident?
I don't know. I just know that it was green, but I don't know how long.
Would that be approximately 1 minute?
Excuse me, I'm going to clarify with the witness.
Okay.
How is it I'm going to watch the light for 1 minute?
Earlier, you testified that from the time you first saw your traffic light until the time of the accident was approximately 1 minute or less. Is that correct?
Objection. It's argumentative as to your interpretation of prior testimony, and I believe misstates what she said. I instruct the witness not to answer.
Is it your testimony that from the time you first saw your traffic light to the time of the accident that was approximately 1 minute?
Objection. Misstates prior testimony.
I'm asking her if that's her testimony.
Then it's been asked and answered, and I'm going to instruct the witness not to answer it.
Okay, then we'll back up and clarify then. You said that from the time you saw your traffic light until the time of the accident, it was less than 1 minute. Do you know if it was less than 60 seconds?
Objection. It's been asked and answered. You've asked her many times to state an estimate of this interval that you keep referring to. She's been unable to do so.
Well, I'm entitled to confirm that she doesn't know. I mean, I can break it down.
You have confirmed that. She's been asked that same question now about 10 times in various forms, and she's been unable to provide us with an estimate. And I think you're wasting time here to do that.
Well, I'm entitled to get the best estimate I can get. Less than 1 minute doesn't tell me a whole lot. There's 60 seconds in between nothing and less than 1 minute. So,
I understand that you're attempting to do that, and she's been unable to help you in that regard.
well, I'm going to try and break it down and see if I can get a clarification.
You've already done that.
Do you know whether or not it was less than 60 seconds from the time you first saw your light until the time of the accident?
Objection. It's asked and answered. Instruct the witness not to answer.
Counsel, I'm entitled to break it down. I can go through it in time segments. If she can't answer and she says, I don't know, that's fine, but I'm entitled to break it down as much as I can. Less than 1 minute tells me nothing. I'm entitled to break it down more than that unless you're willing to stipulate that her answer is she doesn't know at all.
She has given you her best estimate. She said it was less than a minute, and she was unable to specify other than that.
Well, like I said, I'm entitled to break it down. And if you're going to instruct her not to respond, I'll go in on a motion. I'm entitled to break it down. Less than 60 seconds. We're talking about a light here.
If you would quit asking her the same question, maybe I would allow it.
It's a different question. Why don't you allow her to answer it?
Between 1 minute and 60 seconds, you're calling this a different question?
Well, I'll break it down to the next one. Do you know whether or not more than 50 seconds went by from the time that you first saw your traffic light until the time of the impact?
No.
Could it have been more than 50 seconds that went by from the time you first saw your traffic light until the time of the impact?
Objection. Calls for speculation. Instruct the witness not to answer.
Well, it doesn't call for speculation at all. She was there. We weren't. It's her testimony. If she doesn't know, she doesn't know. But if she can answer it, I'm entitled to know what her response is.
I was going to instruct her not to answer any questions in which you ask, could it have been? Because that calls for speculation. If you want to ask her if she knows or can give an estimate about certain time periods, that's fine.
Is your best estimate that it was more than 50 seconds that went by from the time you first saw your light until the time of the impact?
Objection. It's been asked and answered. She already said she didn't know if it was more than 50.
I believe my question asked her if it was less than 50. So,
You're right.
do you understand the question? Do you understand the question?